Good morning. I'd like to call this public hearing of the Committee on Health to order. Today is Thursday, October 17th. The time is 9:33 a.m. I'm at-large Councilmember Christina Henderson, Chair of the Committee on Health. We are in room 500 of the John A. Wilson Building, and this is a hybrid hearing with public witnesses testifying both virtually and in person, and our government witnesses testifying in person. Today, we will consider Bill 25-930, the Consumer Health Information Privacy Protection Act of 2024. This bill was introduced by the chairman on behalf of Attorney General Ryan Schwab on July 12, 2024. The bill aims to establish consumer protections for health data collected by entities that are not covered under the federal HIPAA protections. Before diving into the specifics, I'd like to describe the key differences between HIPAA protections and the proposed Consumer Health Information Privacy Protection Act protections, which is referred to as CHIPPA. Acronyms, here we are. HIPAA, the Health Insurance Portability and Accountability Act of 1996, established privacy protections for individuals' medical records and other identifiable health information collected by insurers, hospitals, and health providers. CHIPPA aims to regulate the privacy of health consumer data collected, shared, and processed by entities that fall outside of the HIPAA scope. Examples of such entities include those that are fitness-focused mobile apps, devices, data brokers, social media companies, search engines, websites, and advertising firms. The legislation would impose several new requirements on regulated entities that collect, sell, share, and process consumer health data. This bill also includes regulations for third parties, affiliates, and processors who receive, use, store, and manage consumer health data. Specifically, the bill would require regulated entities that collect consumer health data to have consumer health data privacy policy containing specific information about its collection, use, and sharing of the data posted on the homepage of its website. It prohibits regulated entities from contracting with processors, affiliates, or third parties to process consumer health data in a manner that's inconsistent with the privacy policy. It mandates that regulated entities obtain consumer consent before collecting consumer health data and inform consumers about how and when that data will be shared, collected, or sold. And it prohibits the establishment of geofences around locations where health services are provided. This bill also establishes procedures for addressing improper data collection practices and introduces new consumer protection rights. Under the bill aims that consumers will have the right to access information that has been collected and shared with regard to their health data and withdraw collection at any point, or withdraw consent, excuse me. Additionally, before any consumer health data can be sold, the consumer must provide explicit authorization. Finally, the bill limits the regulated entities' collection and sharing consumer health data for the purposes contained in the consumer consent. I don't see any of my colleagues who have joined, but obviously if they do, we'll certainly welcome them to provide opening statements. I do want to mention sort of the timeliness of this legislation. As you all know, or not all, I'm making broad assumptions, but this has been in the news lately as it pertains to one company, 23andMe, which is experiencing some financial challenges. And it turns out that their largest asset is the health data, genetic data that they have been collecting. There's also an additional concern around whether or not entities or governments will try to use health data to criminalize the health decisions of consumers. And so I hope we can have a robust conversation about all of these things and more today. So for our public witnesses, individuals who are representing organizations will have 5 minutes to testify, and those representing individuals will have 3 minutes to testify. You're more than welcome to submit longer testimony for the record, which of course we will review, but we want to give everyone an opportunity to be heard on today. All right, so for our in-person witnesses, I have Suzanne Bernstein from the Electronic Privacy Information Center, Justin Palmer, who's the Vice President of Public Policy and External Affairs for the DC Hospital Association, Matt Schwartz from Consumer Reports, and Emerald Teese, apologies if I'm saying your last name incorrectly, from the Center on Privacy and Technology at Georgetown Law. Suzanne, when you're ready, just push the button right in front of you. There you go. You're on.
Awesome. Good morning, Chair Henderson and members of the committee. Thank you for the opportunity to testify in support of the Consumer Health Information Privacy Protection Act. My name is Suzanne Bernstein, and I'm counsel at the Electronic Privacy Information Center, otherwise known as EPIC. We are an independent nonprofit research organization here in Washington, D.C., established in 1994 to protect privacy, freedom of expression, and democratic values in the information age. In my testimony, I'll explain why it's urgent, as you mentioned, that the Council act to protect consumer health data privacy, provide an overview of the health data privacy risks that this bill will mitigate, and highlight two of the most important aspects of CHIPPA: enforcement mechanisms and the definition of consumer health data. It's time for DC Council to act to meaningfully protect consumer privacy. To set the stage, Congress has failed to pass a comprehensive federal privacy law, or a law specifically aimed at protecting consumer health privacy. States are stepping in and enacting state-level comprehensive data privacy laws, or laws that specifically are aimed to protect consumer health data, like Washington State's My Health, My Data law that went into effect earlier this year. By passing CHIPPA, DC has the opportunity to remain a leader in consumer protection and set the bar high for Congress to do the same. Consumer health data has skyrocketed in recent years, the collection of that data. The broad availability and convenience of smartphones and internet access has enabled Americans to turn to apps, platforms, and other online sources to track diseases, diagnosis, treatment, medications, fitness, fertility, sleep, and other mental health, diet, or vital issues. Our understanding of what constitutes health data has grown as data analysts and data brokers have demonstrated their ability to infer health-related insights from a widening range of data sources. But unbeknownst to many consumers, most of this health data collection is not regulated by HIPAA. Most of the apps, platforms, and companies that collect our most sensitive data, like, as you mentioned, Chair Henderson, direct-to-consumer genetic testing companies, fall outside of HIPAA's narrow scope. The current gap in regulation of consumer health data poses significant risks to consumers. The mismanagement or breach of sensitive health data can result in a wide range of privacy injuries, from stigma and humiliation to financial or reputational injuries. What's more, the largely unregulated data brokerage ecosystem that constantly collects, analyzes, and sells health data without consumer knowledge or consent poses stark privacy and data security risks to consumers. Data brokers sell health data, including mental health information, to willing buyers, including commercial entities, health insurance companies, law enforcement, and nearly any interested individual. In recent years, the Federal Trade Commission has stepped up its enforcement actions related to health data privacy, but these apply only after a privacy or data security violation has already occurred. DC has the opportunity to provide our consumers with preventative safeguards for their consumer health data, mitigating potential risks or harms before they materialize. Turning to CHIPPA, I want to highlight two important provisions that will go a long way to protect consumers. First, CHIPPA's private right of action rightly ties into DC consumer protection law. As CHIPPA makes clear, a privacy violation should not be treated differently from any other unfair or deceptive trade practice. Individuals and groups of individuals who use online services are in the best positions to identify privacy issues and bring actions to vindicate their interests. Allowing consumers to enforce their own privacy rights preserves DC's resources, and statutory damages ensure that companies will face real consequences if they violate the law. Private rights of action are extremely effective in ensuring that the rights in privacy laws are meaningful for consumers. Another important aspect of CHIPPA is the definition of consumer health data. The bill defines consumer health data as personal information that is linked or can reasonably be linked to a consumer that identifies the consumer's past, present, or future physical or mental health status. As I referenced earlier, the expansive scope of health data and health-related inferences that can be drawn from data collection require a broad definition like this one for CHIPPA's protections to be effective. Thank you for the opportunity to speak today. EPIC is happy to serve as a resource to the committee on these issues and plan to submit supplemental testimony before the record closes on October 31st. Thank you.
Thank you so much. Mr. Palmer.
Good morning, Chair Henderson and members of the Committee on Health. My name is Justin Palmer, and I'm the Vice President, Public Policy and External Affairs for the District of Columbia Hospital Association. I appreciate the opportunity to present testimony on the Consumer Health Information Privacy Protection Act of 2024. DCHA is a unifying force advancing hospitals and health systems in the District of Columbia. We are committed to promoting policies and initiatives that strengthen our system of care, preserve access, eliminate disparities, and promote better health outcomes for patients and our community. Our driving vision is to achieve an efficient and effective healthcare delivery system that supports a healthy, equitable, and vibrant community. DCHA and our members realize the immense responsibility and trust patients place in our organization as we handle sensitive and private health information. As entities covered under the Health Insurance Portability and Accountability Act, or HIPAA, healthcare providers' use and disclosure of health information is tightly regulated. Violations of HIPAA are quite serious and are enforced by the United States Department of Health and Human Services Office of Civil Rights. While we support the intent of the legislation before you today, our members believe more work needs to be done to avoid unintended consequences. At a minimum, the Hospital Association requests a complete exemption of HIPAA-covered entities and their business associates from this legislation. While the introduction letter indicates that is the intent, a closer look at the language suggests it only exempts HIPAA-covered health information, not the entities. This creates unnecessary ambiguity. HIPAA already outlines the rules regarding disclosure and review of patient information. Also, HIPAA-covered entities are required to provide patients with a notice of privacy practices. We also have concerns over the broadness of the geofencing prohibitions around healthcare delivery sites, particularly for those entities themselves. As technology advances, geofencing may be integrated into registration and check-in processes to better serve patients. A total prohibition of the use of this technology, particularly by those providers delivering care, may create an unnecessary burden. This provision could affect the ability to use location services for websites and locator features. For example, a hospital may collect aggregate data on locations of people accessing their public website or participate with Google if a person puts into the Maps app hospitals near me, and the entity could come up as a location near them if they are using the location services. Again, we don't oppose the protection of consumer health data and realize its importance, but we believe that stakeholder engagement is necessary before this legislation is adopted to understand how it impacts the delivery of care and use of data by regulated entities. Thank you for allowing me to testify, and I'm happy to answer any questions.
Thanks, Mr. Palmer. Mr. Schwartz.
Chair Henderson, thank you for allowing me to testify today, and thank you for your attention to the critical issue of data privacy. My name is Matt Schwartz, and I'm a policy analyst with Consumer Reports, based here in DC. CR is an independent, nonprofit, and nonpartisan organization that works with consumers to create a fair and just marketplace. To give some background, Consumer Reports has been heavily involved in the legislative push by states around the country to introduce and pass strong privacy laws. As you may know, and as Suzanne said, Congress has tried and failed to pass a privacy law for years now. And so it's fallen to the states to step up and protect their constituents. And as you also might be aware, tech companies have made the rounds across states to try and thwart our attempts to pass strong privacy laws, in many cases going as far as lobbying lawmakers to pass their own favorite model of privacy legislation in lieu of stronger protections desired by consumer and privacy advocates. Companies care so much about these rules because they're increasingly surveilling our every move online. Our browsing habits, our precise geolocation, information about kids, and at issue today, information about our health. It makes sense. Our data is incredibly valuable, not just to companies who want to learn more about their customers so they can sell more stuff, but for specific industries like insurance that believe they can make better informed underwriting decisions if they could only have more detailed information about our lives. The problem, of course, is that this incentive structure has resulted in an erosion of the basic expectation of privacy, and it can lead to even more concrete harms, like the ones you already outlined about reproductive health, and having our health data for sale in the open market in a largely unregulated fashion and also lead to outcomes like unfair insurance pricing or denial of important life opportunities like housing, healthcare, loans, or job opportunities, all based on information that we might not have even known that we were sharing in the first place. That's why we're glad to see DC is taking steps towards giving consumers more control over how their health information is collected and used. We support CHIPPA. We already shared some written comments with the committee, so I'll just share 3 main points for now. First, as Suzanne outlined, this bill has a strong definition of consumer health information that includes information that identifies a consumer's past, present, or future mental or physical health status. Information about our health extends far beyond the type of data we provide during visits to, say, a traditional healthcare provider. Companies can cobble together what would seem to us wildly disparate data points about our shopping habits, location data, and web activity to make strong inferences about us and our health that are then sold and shared with other businesses. This bill makes the basic point that we should at least know when companies are collecting this type of info about us, and we should be able to object to its sale. Businesses will argue that this type of understanding means that any data could be health data, which will grind the entire system to a screeching halt. But this bill and its antecedents in other states clearly states that the data must be used to identify someone's health status, which is an appropriate threshold for protection in our view and hasn't resulted in the sky falling in other jurisdictions where this type of bill has passed into law. Second, the bill creates a tiered consent framework whereby businesses must receive consent to collect consumer health data, separate consent to share it, and written authorization to sell it. This is a reasonable risk-based approach to consent, though we would urge the committee to consider whether an outright ban on the sale of health data might be worth pursuing either in this legislation or in the medium term through another vehicle. It's unclear how the sale of one's health data would benefit the consumer in most circumstances. And so by requiring consent, bless you, we do risk overburdening consumers with unnecessary consent requests that they're unlikely to grant and that do not provide a clear societal benefit. Other jurisdictions, like Maryland in their recently passed comprehensive privacy law, simply ban the sale of all sensitive information, which includes consumers' health information, among numerous other categories of information. Finally, we note that the bill would be enforced in part by a private right of action, which we believe is appropriate in order to help incentivize businesses to comply. We strongly encourage legislators to retain this provision as under an AG-only framework. Businesses that recognize the AG is only capable of bringing a handful of cases might simply ignore the law and take their chances in evading detection. We need more aggressive enforcement if we actually want these provisions to be honored, and some form of a PRA is the best way to get there. I'll wrap it up there. Thanks for the time, and I'm happy to answer any questions you might have.
Thank you. Emerald.
Good morning, Chair Henderson and members of the committee. Thank you for the opportunity to speak to you today. My name is Emerald Say, and I am testifying in support of the proposed Consumer Health Information Privacy Protection Act, or CHIPPA. I'm here on behalf of the Center on Privacy and Technology at Georgetown Law, and the Privacy Center is a research and advocacy organization that focuses on the privacy rights of historically marginalized groups. This includes the privacy implications of commercial data practices, such as the management of consumer health information. The Privacy Center will submit full written testimony following the hearing, and I will summarize them here in 3 points. My first point is that many consumers are unaware that existing privacy laws like HIPAA are insufficient to protect personal health information. When people visit the doctor's office, they expect that the information they share will be protected due to laws like HIPAA. And although HIPAA has been considered foundational for health information privacy in the US, it is limited in scope. It only applies to certain entities providing medical services, such as hospitals and doctors' offices. In our increasingly digitized world, HIPAA is insufficient to protect consumer health information. The same sensitive information that gets shared in the clinical setting often ends up in the hands of organizations and individuals who are not subject to the same rules. For example, 98% of hospital websites use tracking software to transfer information to third parties that are not covered by HIPAA, including social media companies, advertising firms, and data brokers, as you mentioned before. 82% of consumers are unaware that HIPAA's privacy protections do not apply to the health data in mobile apps. At the same time, nearly 2/3 of US adults have used health-related apps such as exercise, nutrition, and mental health apps. And of those, a majority uses these products daily. As a result, many consumers frequently share sensitive and personal health information under the assumption that it is protected when it actually isn't. And CHIPPA seeks to address this issue. My second point is that private companies have been exploiting gaps in the law. As consumers continue to share information with health-related apps and websites, the companies that collect and use that information have repeatedly made news for inappropriately sharing and selling that data to data brokers and other third companies. A 2022 investigation, for example, found that dozens of telehealth companies, including Curology, Hims & Hers, and Talkspace, shared information such as consumers' prescription medications, health conditions, and family health histories. CHIPPA will ensure that when consumers share their health information with these companies, those companies are obligated to protect it. Third and last, CHIPPA works to close the legal loopholes that enable the inappropriate use of sensitive health data. In response to concerns about the failure of federal law to protect sensitive health information, states have begun to pass their own laws. And with CHIPPA, DC could join them in setting a powerful example for other states looking for ways to protect the sensitive health information of their residents. One important precedent that CHIPPA would set is its strong definition of consumer health data. And this definition reflects the massive volume and diversity of sensitive health information that companies are profiting from in the absence of consumer protections. So the scope of this definition is appropriate. CHIPPA also creates a robust enforcement framework. By referencing DC's unfair and deceptive trade practices law, it creates a private right of action. And to understand the strength of this provision, we can look to privacy laws from outside of DC that don't have it. State comprehensive privacy laws that leave enforcement to state agencies have enabled companies to maintain their harmful business practices. And without a private right of action, companies have continued to collect, use, share, and sell sensitive health information at the expense of consumers. And we know from past experience that a private right of action can be quite effective at incentivizing companies to change their data practices. Using a similar provision in Illinois' biometric privacy law, for example, consumers pushed Facebook to stop collecting face scans by default and eventually shut down their face recognition system that it used to identify people in photos and videos. So CHIPPA is a critical step towards stopping companies from taking advantage of health information that consumers share with them. And thus, the Privacy Center urges the committee to move this bill forward. And thank you for your attention to this issue.
Thank you. And thank you so much to all of you for your testimony. I have some follow-up questions. Ashley, go ahead and give me 10 minutes because 5 is just, that's hopeful, but I'm not going to be there. Okay. Some follow-ups. So I appreciate in terms of, I think for at least 3 of you, you're talking about how CHIPPA closes a loophole in terms of what can be covered or not be covered. And I appreciate, Ms. Say, you talking about that most people don't know that HIPAA is limited, that HIPAA hasn't been updated in quite some time to address some of these particular concerns. But I would imagine that some of these technology companies would argue, oh no, we're covered by HIPAA, we're only sharing data in the aggregate. What are your thoughts on that? Individual information, like they're not, they would say, we're not sharing individual information, we are sharing information in the aggregate. Yeah.
So HIPAA initially was passed as a law designed to figure out how to share medical records between hospitals, patients, and other related business entities like insurance companies. So it's a portability act. There's a HIPAA privacy rule, but HIPAA itself wasn't designed. And even if it was updated in some way, maybe that's not the right way to protect all this consumer health information. I think HIPAA aside, there's a lot of information that colloquially or literally would be considered health information, right? So if your search queue of looking for medications online or your fitness tracker or your period tracker or location data that can reveal you were at a certain clinic or dialysis center. That kind of information can identify, as the definition reflects, certain health information about yourself. And the value of that is reflected in this broader commercial surveillance ecosystem because health information is very lucrative. It can lead to very distinctive and detailed ideas and images of profiles of consumers that are used for advertising or other purposes. And there's really no limits or regulation about how that information is sold. But in response to your question, I think it's not really in the aggregate because this information is used to profile consumers. So it's kind of the opposite of that.
Okay, I hear you on that. Mr. Schwartz, you talked a little bit about Maryland and how they sort of addressed this through their larger consumer protection law and that they did an outright ban on the sale of health data. What about when a company owns other companies who collect that information? So for instance, One Medical is owned by Amazon. Technically, they haven't sold that information to Amazon, but now Amazon does have access to it. How do they approach that?
I mean, you're right. That would not constitute a sale under the definition. I mean, there's things that you can do to tighten that up. I mean, yeah, this is an increasing problem as companies gobble up more and more separate companies,
Yeah,
right?
I'm thinking about this from like, if I look at the health landscape, the number of VCs that are now buying primary care clinics and dental offices and, these specialty care buying, acquiring.
Yeah.
How do we handle that data sharing there when it is part now of a larger
Yeah.
entity?
I mean, you want to make sure that whatever data transfers are happening are within the reasonable expectations of the consumer.
Okay,
So sometimes the way that these laws get at it is by saying it's not a sale if the businesses are commonly branded, right? So if One Medical is One Medical by Amazon, at least the consumer would have a reasonable expectation that the information that they share with One Medical might be making it up to the mothership at some point.
Mhm.
But, we don't, we don't want a situation where those connections between companies are opaque to consumers.
Okay,
And so they might not even realize that when they're going to their telehealth visit, that information could be used, for a completely unrelated arm of the business to do profiling or targeted
Right.
advertising or something like that. So it's kind of about getting to the corporate structure and the reasonable expectations of consumers that information would be shared.
okay. Besides Washington State, who else has taken on this type of legislation? It might not be specifically focused on health data. Like you mentioned, Maryland has this as part of their larger bill. I think you mentioned another state that did, Illinois dealt specifically biometric data. Is this a trend that we're seeing across the country of, I guess, states and localities needing to act in the failure of Congress doing so?
Yeah, so Nevada and Connecticut have also passed laws that focus specifically on consumer health privacy protections. However, those laws don't include a private right of action.
Okay,
And so we're still, and again, the Washington State's My Health, My Data, which is very similar to CHIPPA, went into effect in April. And we're still seeing how all of these, the enforcement, how all these laws are panning out, but there does seem to be momentum to protect this type of information. And like Matt mentioned, there's also provisions within state level comprehensive privacy laws that protect categories of sensitive information, which include health information, can also include privacy of minors information, things like that. So it's important to also look within the provisions of these state level comprehensive privacy bills as well.
okay. Mr. Palmer, I want to ask about a couple of things you brought up, and I appreciate you representing the hospital perspective here. Part of your testimony about geofencing, though, kind of sort of raised my eyebrow, if you will. When I'm going to a hospital or if I'm going to a primary care facility, yes, many of these institutions have moved to a technology-based check-in system, but I never get a prompt on my phone that says, I see you're in the area, you want to go ahead and check in for your appointment.
I think we're just raising things to consider. I
Okay.
don't know that we're using that yet. I mean, when I go to Kaiser, I check in on my phone but I don't know what we wanted to do is just raise as we're thinking about this, what some of if there are things to consider about what it means for geofencing, particularly for the provider itself.
Okay. That's fair. And this is always the joys of these types of bills, right? There's just some specific things that I'm trying to prevent from happening. And then there's some other parts that I don't want to prevent innovation from taking place. But I also,
And we're not, we understand the consumer privacy. It's one of the reasons when we were talking about DPW having access to do card readers in health facilities, we raised concerns because of the
Oh, yeah, that's right.
reproductive. And so we just want to have the discussion,
Yeah.
whether where we come to an end, that's what we're encouraging, just raising as I'm thinking through the impact, these are things to consider. But we definitely understand the need to protect consumer health data.
Okay.
Particularly our patients. We're very, very sensitive to that and accessing service within our facilities as well.
okay.
That's why we have had concerns with body worn cameras being active within healthcare
Health
facilities and things like that.
Right. Okay. Let's talk a little bit about consumer informed consent, or rather making consumers sort of aware of this information. So yesterday I log on to Twitter. I'm gonna call it Twitter because that's what its mama called it at the beginning. And there was a pop-up that says, we've updated our terms and services and privacy policy, click here. Now, because I am increasingly suspicious of the owner of such company, I actually clicked on it and read it. But I would imagine for a variety of individuals, they just like sort of swiped it away or said, okay, gotcha, but never looked at it. And I think that is something very similar that happens with some of these apps. So when you're signing up, they'll tell you, here are our privacy terms and conditions, X, Y, or Z, but very few people are actually sort of reading through it. But it's been provided to them, right? And it's been provided to you at the front end of you deciding to choose to use this particular service. Is there anything more we can do? Or is it just a situation where like, I could provide water, but I can't lead you to it?
I mean, I think this bill has been thoughtful about this idea of consent fatigue, or at least this idea that most people aren't, very closely reading the terms and conditions and the privacy policy when they sign up. This bill says that the consent that you provide has to be specific and separate from all of that. So ideally, the consumer would be presented with like a standalone notice that's telling them, here's your health information, this is what's being collected, this is where it's going. And
Separate and apart from
Yes.
the standard terms and conditions
Yes.
agreement.
And ideally, that would give, a heightened, opportunity for the consumer to actually think through the implications of sharing their health data with that company and where it might be going. I mentioned why, a ban on sale of sensitive health information might be preferable. And that's also one way to get at that consent fatigue issue that people are just swiping through. There might be some practices where we just think we shouldn't be asking people 10 times a day whether they want their information to be sold or not.
Right.
Maybe there's certain things that we should just make a decision that they're not, societally beneficial. And so we should just cut
Okay.
it off there.
All right, that's helpful. Please make sure you all submit your written testimony for the record if you just go to the council website and upload it. I don't have any further questions for you all at this time, but I definitely look forward to working with you guys on this. For your background and knowledge, and also for the folks who are listening, this is not my first privacy bill. When I was a staffer at the council, I did a privacy bill on student education data. But I also want to give a heads up to the technology companies that did not sign up to testify. I'm not doing what I did like 8 years ago and taking a year to work on this bill. So you didn't sign up to testify. So tell your lobbyists it's time to contact our office if you have some particular concerns. All right. Thank you all so much. Okay. Were there anyone else for public witnesses who you're here in person and you wanted to testify? Anybody else? Okay, all right, so we're going to turn to our virtual witnesses. Margaret Durkin from TechNet, Andrew Kingman from State Privacy and Security Collection, Keith Lake from the America's Health Insurance Plans, and Andrew Crawford from the Center for Democracy and Technology. If this is the first time that you're testifying virtually with us, you have to affirmatively accept our invitation to become a panelist. There'll be a little pop-up that happens on your screen, and we'll just give it a minute while you all come into the room. All right, I'm just having a little technical difficulty on my side. I can't see everyone, but I think Ms. Durkin is here. So when you're ready.
Good morning, Chair Henderson and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director with TechNet, a technology trade association. Thank you for the opportunity to speak today on B25-0930, the Consumer Health Information Privacy Protection Act of 2024. TechNet and its member companies agree that the protection of consumer health data is of utmost importance. However, we are concerned about this bill largely due to its many outlier provisions in the bill. In the absence of a federal privacy standard, interoperability among states is key. And getting things such as definitions tailored narrowly to make sure that both consumers and businesses know what is expected of them is incredibly important to all parties involved. I'll be submitting written remarks for the record after this hearing, but for the purposes of time, some definitions that we would note we would like to see amended include the definition of consumer health data, personal information, and precise geolocation, to name a few. The bill lacks an exemption for the collection of consumer health data that is necessary to provide a consumer with a product or service that they choose to use. Regarding the health-specific privacy policy, many, if not all, entities already have a privacy policy that is public, and we believe that any privacy policy information that includes health data should just be put under that privacy policy and not require companies to create a whole separate policy related to health. Regarding the data deletion requirements, this could impact products that consumers use over a length of time. So for example, if a consumer uses an app to track their daily steps, their weight fluctuations, or sleep over days, months, and even years, we're concerned that the deletion requirements within this bill would impact a consumer's ability to use the services they choose. Another outlier in the bill we note is under Section 5, letter A, related to companies having to provide a list of third parties. That is an outlier to many other states. Other states simply ask for the categories. And I will note also in Section 5, letter L, the requirement relating to deleting data for an entity that has dissolved or terminates is an outlier and would be tough for companies to operationalize and comply with. Regarding consumer data access, the statement as expeditiously as possible and without unreasonable delay is open to interpretation and offers little guidance for business. Thank you to the sponsors and those who helped draft the bill for providing for a list of exemptions in the bill as introduced. We are requesting, though, that the exemption list includes DC medical records that are specific to the district. Some of our member companies don't use or accept insurance, and therefore they don't fall under HIPAA. So we're requesting that DC specific medical records they deal with be included in the exemption list. There's been a lot of mention of a private right of action. So TechNet is opposed to private rights of action as we believe that these can be frivolous in nature and take valuable resources away from companies. Accidental good faith mistakes, such as unintentionally omitting a category of data, should not create huge litigation risks. There was a mention of the 2008 Illinois BIPA law. I would like to note for you and the committee that the governor of Illinois did sign a reform law in August of 2024. Due to the extreme amount of lawsuits that were brought, the legislator and the governor recognized a need to reform this bill that was passed in 2008. We believe that enforcement should rest solely with the Attorney General. As an alternative to a specific consumer health privacy law, we are suggesting to the committee and the council as a whole to potentially consider a comprehensive privacy bill, which allows for several rights for consumers, including rights to access, delete, and port their data, to name a few, as well as an opt-in regime for sensitive data, which includes physical and mental health conditions. For the reasons listed above, TechNet is opposed to this bill. However, we look forward to working with the committee, and I'm happy to take any questions. Thank you.
Thank you. Mr. Kingman?
Hi, good morning, Madam Chair and members of the committee. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a multi-sector coalition. I also am a privacy attorney with a background in compliance, helping clients work through various privacy laws throughout the country. As a coalition, we believe strongly that sensitive data deserves heightened protections. And we're here in opposition today because, as drafted, the bill is overbroad and it has numerous compliance ambiguities that will be further exacerbated by the presence of the private right of action. Furthermore, the overbreadth will not help consumers. To the contrary, it's likely to create a deluge of opt-in consent notifications, which will dilute the value of consumers being able to consent to the collection and use of that health information that is truly health information. In other words, consent becomes meaningless if it becomes routine. You can think of the cookie banners that I'm sure many of us click through every day. So we believe that adding elements of intentionality to the consumer health data definition and related data elements, as was done in subsequent versions of this bill in Nevada and Connecticut, will improve this bill's clarity while providing even stronger protections for consumers. I also want to mention and thank the Attorney General's office for being willing to engage in stakeholder conversations. We've had several cordial conversations with them and look forward to continued discussion with them and hopefully with this committee as well. Again, as I mentioned, the consumer health data definition extends beyond traditional health information. And even more so, it applies to information that a company may well not be using to make health-related inferences. So as an example, companies may feel compelled to classify purchases such as deodorant, makeup, or clothing as consumer health data when in fact they're not using this data to make health inferences. I'm a type 1 diabetic, right? And so every food purchase at a grocery store that I make theoretically could have a health implication. As drafted, the grocery stores from which I buy food may feel compelled to classify that as consumer health data, even if they're not making health inferences. Our position is that if that grocery store is making health inferences about the fact that I might be diabetic based on my food purchases, that they should fall within the auspices of this law, but that absent such activity and such intentionality of saying we're making the choice to do this, that should not be considered consumer health data. And unfortunately, the way that this bill is drafted, we're dealing with that overbreadth. So we think that adding that intentionality could be much clearer. Additionally, the definitions of collect and consumer are overbroad. The definition of collect contains the term processing, which is the umbrella term for any type of processing of data, which means that consumers may have to provide opt-in consent, not just for the initial collection of data, but for any subsequent processing, such as storage. The definition of consumer applies to anyone who may be located within the district, and particularly a jurisdiction like Washington, D.C., where people live in Maryland and Virginia, where there are lots of tourists. This could have really, really anti-privacy consequences, incentivizing companies to track people in and out of the district because and anytime they're in the district, they would be defined as a consumer. I want to take a minute and talk about the private right of action because we've seen what happens when states put PRAs in their privacy statute. A recent Reuters article noted that privacy litigation is the fastest growing sector of litigation in the country. And a PRA rewards plaintiffs' consumers and not plaintiffs' lawyers and not consumers, even when a violation has been shown. Studies have shown that attorneys typically collect 4 times the amount of money that goes to consumers. And a Consumer Financial Protection Bureau study showed that of 562 cases, only 87% of resolved class actions resulted in no benefit to absent class members. It either dismissed by the court or settled with the named plaintiff only. You've heard about Illinois. We've seen similar efforts in California. And when you have a bill like this with so many ambiguities and so much overbreadth, it's fodder for frivolous lawsuits. So we oppose this bill, but we do support heightened protections for sensitive health data and would love to continue working on the bill to get this where it needs to be. Thank you very much. Happy to take any questions.
Thank you. Mr. Lake?
Yeah, good morning, Chair Henderson. My name is Keith Lake, and I'm a Regional Director of State Affairs for AHIP. If you're not familiar with AHIP, we're the national association whose members provide healthcare coverage, services, and solutions to hundreds of millions of Americans and hundreds of thousands of DC residents. My members' health plans have long been a leader in developing privacy practices to protect personal health information. And for that reason, AHIP supports the overall objective of this bill. When you open this morning's hearing, Chair Henderson, you explain the differences between HIPAA, the longstanding federal law, and this CHIPPA bill. And one of the things you noted is that the purpose of CHIPPA is to address health data collected by entities that fall outside of the scope of HIPAA. However, the way the bill is currently drafted, it presents several challenges that AHIP believes must be addressed to prevent unintended consequences for health insurers that are already subject to the privacy standards under federal laws, not just HIPAA, but also the Gramm-Leach-Bliley Act. So the main issue that we identify with the bill is really the same issue raised by an earlier panelist, Mr. Palmer of the DC Hospital Association, in the testimony that he offered. And that's on Section 11 of the bill, which attempts to carve out certain types of data for exemption from CHIPPA's requirements, but it does not explicitly exempt entities that are already subject to HIPAA or to Gramm-Leach-Bliley. And this distinction between exempting data and exempting entities is not merely a technicality. It's got real-world implications for compliance for health insurers. In particular, while the bill rightfully, we think, attempts to exempt health information, it does so in a way that will likely cause confusion. For instance, it refers to health information rather than protected health information, or PHI, as defined under HIPAA. This, we're concerned, could create ambiguity for the covered entities, leading them to question which specific data falls under this exemption. And as written, health insurers would face the difficult task of identifying what information they might have that falls within the exemptions and what does not. Yeah, so in order to address those concerns, we strongly recommend that the council amend CHIPPA to include entity-based exemptions for HIPAA-covered entities and for Gramm-Leach-Bliley regulated institutions. This would align the bill's regulatory framework with effective privacy laws that have been adopted in other states, as been previously discussed here today. In other states where entity-based exemptions for entities that are subject to HIPAA or Gramm-Leach-Bliley are incorporated into their laws. We think an entity-based approach will help avoid the compliance challenges this bill could create, and also could simplify enforcement for the regulatory agencies, which would save the district administrative and governmental resources. So while we support the goal of protecting the personal health data of district residents, Entity-based exemptions are necessary to ensure that businesses already operating under and complying with current federal law are not potentially subjected to duplicative and confusing requirements. Thank you.
Thank you, Mr. Lake. Please don't leave because I have some follow-up questions. Mr. Crawford?
Hey, good morning, Chair Henderson. Thanks for the opportunity to testify today. My name is Andrew Crawford. I'm a senior policy counsel here at CDT, the Center for Democracy and Technology. CDT is a leading nonpartisan nonprofit organization fighting to advance civil rights and civil liberties in the digital age. I lead CDT's work at the intersection of health, technology, and privacy. And I commend this committee and the council at large for focusing on these issues and working on solutions designed to keep individuals' health data private. CHIPPA is a strong proposal and goes a long way to preserving the privacy of DC residents' health data and rebalancing the rules around how health data is collected, shared, and used. With some additional amendments that I'll discuss below, I believe the bill will be well positioned to protect the privacy of some of DC residents' most personal and sensitive data. Preserving the privacy of health data is vitally important. There are countless instances, some of which have already been mentioned today, when consumer health data, including reproductive data, has been collected, used, and shared, including shared with law enforcement, in harmful ways. There are many examples of enforcement actions taken at the federal level by the FTC against apps like Premom, Flow, and mental health app BetterHelp for telling consumers they will do one thing with their data when in practice they do the opposite. Therefore, CHIPPA is essential at the district level to better protect consumer privacy. And the bill has several essential provisions designed to do just that. Key elements of the bill prevent companies from collecting or sharing consumer health data when it's not necessary to provide the product or service the consumers requested. These are strong limitations, and they're similar to those found in other legislative proposals, including proposals at the federal level. Data limitations are essential to any privacy bill. If companies can only collect and share health data to provide the specific product or service a person wants, that goes a long way to ensure that data won't be used for those secondary purposes that residents don't want, don't know about. The bill also has robust mechanisms that permit DC residents to better access their data, along with the ability to delete their data. All of these, in conjunction with the data limitations I just mentioned, also engender consumer trust when they go about deciding which apps they want to use. So at this point, let's pivot and talk about one of the elements of the bill that I think can be improved and amended, and that is the consumer consent provisions. At first blush, this type of provision may appear empowering to consumers. It signals to individuals they have agency, control, and provides transparency. In practice, however, consent-centric regimes can overburden individuals and enable the harmful data practices we're actually trying to prevent. So let's break this down a little. The consent provisions in the bill as currently drafted detract from the bill's collection and sharing limitations because those limitations are predicated around consent. Specifically, when predicating data collection, use, and sharing protections around consent, it makes it too easy for consumers to potentially even unknowingly consent to practices that in reality they don't want. Most importantly, the consent provisions place a burden on DC residents to read and comprehend policies that are notoriously complex, not easily digestible and understandable to many consumers. I fear that DC residents may be bombarded with requests for consent each time a company wants to use their health data for things like marketing, for training AI models, or for generating interest-based profiles about consumers. New pop-up windows and banners will potentially repeatedly ask DC residents to consent to additional data uses. As other panelists have already noted, when this happens, people can become quickly overwhelmed and suffer consent fatigue. Overwhelmed and short on time, DC residents, as a result, may simply accept terms and give consent without fully appreciating what they are consenting to. We don't want CHIPPA to create additional obligations on DC residents to read and navigate numerous consent proposals. Instead, the bill should embrace and double down on its existing data collection, use, retention, disclosure, and sharing limitations and put those as the focal point of the bill. Unencumbered by consent, these robust limitations will result in stronger and more privacy-protecting solutions. Health data is some of the most sensitive data, and it should be subject to robust limitations focused around the product and service that the DC resident has requested. If consent must play a role in the bill, it should be more limited and apply only to the transfers of data. These types of transfers are less common, and they're the types of actions consumers really need to be aware of. So to conclude, instead of relying on consumer consent, we should remove burdens on DC residents and will require companies that collect, use, and share personal health data to be good stewards of that data and do the right thing. They should not overcollect, they shouldn't overshare, and they shouldn't overuse consumer health data. Many thanks for the opportunity to testify. I look forward to continuing to work with the council and your questions today. Thanks.
Thank you so much to this panel of witnesses. I do have some follow-up questions. And again, just so you guys know, I usually am able to see the screen of everybody who is online, but I can't. So if you have something to say, you just have to speak up because I can't see a hand if it's raised. Okay, so a couple of things. Mr. Kingman and Mr. Crawford, the two Andrews, if you will, you both brought up a very similar point around concerns with people being bombarded with consent requests. And I think that's a very real thing. Mr. Kingman, you sort of talk about it becomes meaningless when you're asked 50 times. I'm just sort of thinking about every time I go to a new website and they ask me, about cookies, it's just like, okay, I just want to read the article. Like, so, either I X out or no one's actually sort of reading it. And so is it actually being, taken seriously or reviewed? And so I definitely think that we can sort of address some of that consumer fatigue because we don't want it to be meaningless. We do want it to be thoughtful. Let me see. Mr. Kingman, I think you're the only person who's sort of raised a concern about the definition of consumer and sort of saying that it could also mean tourist. How best can we, I feel like we're sort of in a conundrum here because if the federal government was able to sort of act on this, we wouldn't need to define consumer. But is there a better way that you feel would be a more narrow approach here?
Yeah, absolutely. I think the simple approach is to simply define a consumer as a resident of that state, or a resident of Washington, D.C., obviously, in this case. And that's something that's extremely conventional that other states have done in their comprehensive policies, and that allows the companies who are complying to understand who exactly is in the district, right? And
Right.
Who's a resident of the district. And to your point about consent, I think that's appreciate you sort of hearing that concern. I think for us, that's why making sure the definition of consumer health data is narrowed to that data which businesses are actually using to create health inferences. And our goal is that when a consent mechanism pops up, that the consumer takes a minute to say, wait a minute, that's a little unusual. We want to make sure to pay special attention on it. And the way that the bill is drafted right now, our concern is that it's going to relate to that they're going to be getting it, for lots of information that isn't relevant. And then with the definition of collect, including the word or otherwise the phrase or otherwise process, that they're going to be getting it multiple times for the same information. And so those are the ways that we think we can make consent more meaningful and strike that balance here.
Okay, I think that is, I think that makes sense. I think the one thing that I would say on the consumer piece, and we'll have to sort of craft this in a way so that it doesn't impact the geofencing parts of this. We have a lot of individuals who come to the District of Columbia for particular health services in particular. And so we want to make sure that their information is protected if they are coming to the District of Columbia for that particular health service. But I think that there is a way to sort of craft it in that way that it's not sort of getting mixed up, if you will.
Yeah.
Although
Sorry, go ahead.
Sorry, I was gonna just ask, is it common though for some of these health apps to ask where you live?
I don't know. I wouldn't want to make
Okay.
a blanket statement or anything like that. But I think for the purposes of this legislation, right? Like if you had to put in your zip code or your shipping address for a particular product, if it was a health product or something along those lines,
I see.
that would probably suffice. But again, I don't want to make generalizations. I don't think that the geofencing provisions would be impacted by the definition of consumer, because the geofencing is around the facility and it prohibits communication within that facility. So by drawing a boundary around the facility and saying, no text messages or targeted advertising, related to this type of activity within that boundary, I think that probably would get at the issue that you're concerned about.
Okay. Mr. Lake, thank you so much for being here. We do a lot of work with AHIP on a variety, our health insurance plans here in the district on a variety of different things. And so I hear you in terms of you echoing Mr. Palmer's request around exempting entities that are already covered by HIPAA. I do want to ask a question. So when a health insurance company might partner with a third-party app for so for instance, sometimes with like Care First, they'll say, oh, you now have access to this particular opportunity on exercise or healthy eating or something to that effect. Do the privacy laws transfer?
Chair Henderson, I don't know that I can give you an answer because I don't honestly know.
Okay.
So under HIPAA, there is definition of covered entity and business associate. Not being an attorney, I don't know exactly whether or not those vendors and those services that you're referencing would fall into those definitions or not, but I can find out and let you know.
Okay, that'd be great if you could sort of follow up on that, because I think that would be the concern of mine is around, I do know that there are some health insurance entities who partner with third-party organizations to provide some additional services to their consumers. And I just want to make sure that there is some clear privacy protections as you all are sort of interacting with that particular company. Ms. Durkin, I wanted to ask a clarifying question or a follow-up question. You covered a lot in your testimony, and so I look forward to reading your full written testimony. But something that you talked about was specifically around deletion. And you made a comment that said the deletion provision would make it difficult for someone to be able to track over time. But in my reading of the legislation, it only requires that you delete information at the request of the individual. There is no you must delete data after 60 days time period. So I just wanted to ask a clarifying if I missed something or if your interpretation was different.
It's my understanding that our members' interpretation was that provision in the bill would limit a consumer's ability to use apps that do track things over time, but I can double check with my members and get back to you to see if something has changed.
Okay. So again, that would be helpful. Again, I'm looking at lines 366 through 338 and kind of goes on further, but it really only says that you must delete at the request of the consumer, but we can sort of get more on clarifying that. Mr. Kingman, I thought it was very interesting. You sort of talked about can food purchases be considered consumer health data? Interestingly enough, of all the people who know things grocery stores know the most about everyone, full stop, period, right? Folks often talk about how Target, they know, your habits on shop, all of these different pieces that you have here. But grocery stores alone only have your shopping habits. They don't necessarily, they can make inferences in terms of health data, but I don't imagine that to be health data on its own, if that makes sense. But you think that
I think that's exactly the point that we're making, right? Which is that the definition as drafted really creates doubt as to whether that would be considered consumer health information, consumer health data. And our point is that if companies make the decision to say we're going to take data about purchasing history or something that is not clearly health data and make health inferences about that. If they're making that decision to go in that direction, then we think that data does deserve heightened protections. But as drafted, that's not what the law is saying. The law is saying that even if you're not intentionally making those inferences, as long as that data could possibly be used, that it would fall within the auspices of this law. And out in Washington State, where the definition is identical to this definition, our understanding is that this is the biggest issue for compliance for companies is are we in or are we out? Hey, we're not doing this. But the way that the law is written, we don't have to be doing it to be within the scope of it.
Yeah.
Our position is that, as is drafted in Connecticut and Nevada, that intentionality of, yes, we've made a decision to make health inferences based on, X data sets, that should determine whether you're falling within the scope of the act or not.
Okay. I can appreciate the desire for clarity. I like usually for definitions to be very clear myself, and often, I get my staff, like if your definition is referencing another definition as part of your definite, like I think it leaves a lot up for interpretation. And a lot of that, when that interpretation happens, will be on the judicial side. And I don't want to give judges the freedom to sort of make an interpretation of where the
Appreciate that.
legislature decided to go there. So we'll take a further look on that. I am over my time. But Mr. Crawford, we'll certainly follow up with you on some of the things that you raised in your testimony. And then, I'll certainly ask our government witnesses some of the things you all raised, particularly around the Illinois 2024 law and some other things as well. So I want to thank you all so much again for being here and for your testimony today. Thank you. Okay, so that concludes our public witness testimony on this bill. Again, I want to stress or invite anyone who did not testify today to submit public testimony for the record, but also invite them before the end of the calendar year to have conversations with my staff if you're having concerns about this. Again, this is not going to be a 6 to 7 month working group on this bill. I would have appreciated if you would have testified today, but I recognize that some of you don't. So don't wait and say you didn't have the opportunity. With that, we're going to take a 5-minute break, and then we'll turn to our government witnesses from the Office of the Attorney General and the Department of Licensing and Consumer Protection. Thank you. Okay, you guys want to come on up? Okay, we are back for the government witnesses for Bill 25-930, the Consumer Health Information Privacy Protection Act of 2024. We now have the government witnesses before us. Adam Teitelbaum, who is the Director of the Attorney General's Office for Consumer Protection, Lindsay Marks, who's the Assistant Attorney General for the Office of Consumer Protection, and Shakira Richardson, who is the Program Manager for the Consumer Protection Unit. Okay, who is presenting testimony? All right.
Ms. Richardson is going to testify for
Okay.
DLCP. I'm April Randall, the Legislative Director.
April, thank you.
You're very
All right. Okay, so you're testifying and Lindsay, you're testifying. Okay, great. All right, so before we begin, all of you who might speak, I have to swear you in, so if you raise your right hand. Do you swear or affirm under penalty of law that the testimony you're about to provide to the Council of the District of Columbia in this committee is the truth, the whole truth, and nothing but the truth? Awesome. All right, so why don't we start with Ms. Marks? Oh, you gotta push the button. There you go. Oh, and just move it closer to you.
Can you hear me?
Yes.
Good morning, Chairperson Henderson, council members, staff, and residents of the district. Thank you for the opportunity to testify before you today in support of the Consumer Health Information Privacy Protection Act, or CHIPPA. My name is Lindsay Marks, and I'm an Assistant Attorney General in the Office of Consumer Protection at the Office of the Attorney General for the District of Columbia, or OAG. With me today is our Director of the Office of Consumer Protection, Adam Teitelbaum. OAG enforces the district's consumer protection laws and works to ensure that consumers remain protected in the digital era, including by bringing actions to protect consumers' privacy and by enforcing DC's Consumer Security Breach Notification Law. I focus in particular on privacy work at our office, and I'm a certified information privacy professional at the International Association of Privacy Professionals. OAG strongly urges the passage of CHIPPA, which would provide district consumers with greater control over how their health information is collected, shared, and sold. Personal health data is some of the most private and sensitive information about us. Most Americans assume that all of their health data is protected everywhere all the time, but that is unfortunately not the case. Gaps in the law allow our sensitive health information to be collected, shared, and sold with little oversight or transparency. When our doctor or our insurance company collects sensitive health information about us, the Health Insurance Portability Accountability Act, HIPAA, requires that that information be kept private. However, when an app, website, or non-HIPAA covered entity collects that same sensitive health information, in the District of Columbia, those companies operate in largely an unregulated space. Without oversight or regulations, companies are collecting troves of sensitive information about us, including information about our mental health, our sexual orientation, prescription medications, health conditions, and our precise location. Some of this collection is done with our consent, and it can be helpful. Data can help us learn about our health, track our habits, and fuel research and innovate treatments. However, our sensitive health information is extremely valuable. And once that data is collected, we have little control over how it is used and who it is shared with. Our sensitive health information is often collected, shared, and sold to third parties on the open market without our knowledge or consent. That has real consequences. Indeed, in a time in which reproductive rights are under attack on all fronts, data about reproductive medical care could be collected, shared, and weaponized against us. Our health information can also be shared and used for alarming advertising purposes. For example, a 2023 Duke University study found that data brokers were selling advertising lists, including the names and addresses of anxiety sufferers and consumers with clinical depression in the United States. Sensitive health data is used not only for targeted advertising, but it is fed into algorithms combined with other data points about us and used to make countless decisions about our lives. For example, our data, including race, education level, TV habits, marital status, and net worth, is purchased by health insurers who use machine learning to make inferences about our health, potential medical costs, and how much to charge us for insurance premiums. CHIPPA has been drafted narrowly to address these pressing concerns and to minimize compliance costs for businesses. CHIPPA requires entities doing business in the district to treat health data with the privacy that consumers reasonably expect and give consumers more knowledge and control over how their sensitive health data is handled. CHIPPA covers only health information and inferences about our health. For example, information about a consumer's purchase of maternity clothes is not covered by CHIPPA. But if a business collects that information and uses it to infer that the consumer is pregnant, then that inference about the woman's pregnancy status would be protected health data under CHIPPA. CHIPPA also only applies to businesses that collect, process, share, or sell health information. If a business is not collecting, processing, sharing, or selling consumer health data, the law would not apply to it. CHIPPA requires businesses to maintain a privacy policy that clearly tells consumers what health information they are collecting, how it is used, who it is shared with, and for what purpose. It gives consumers the ability to choose whether or not their health information is collected, shared, or sold. And it gives consumers the right to find out what health information has already been collected about them, who it's been shared with, and to request that that information be deleted. Lastly, it requires regulated entities to only collect health data that is necessary to provide a service that the consumer requested and to only use, share, and retain the health data for that purpose. These changes would empower DC residents and consumers to protect themselves and control what happens to their most sensitive and personal information. They are also in line with the requirements in place in other state laws, which many businesses are currently complying with. For all these reasons, OAG strongly urges the Council to pass CHIPPA, which will increase transparency and protections for sensitive health information. Thank you again for the opportunity to speak, and myself and Mr. Teitelbaum look forward to answering any questions you may have.
Thank you. Ms. Richardson.
Good morning, Chairperson Henderson, committee members, and staff. I'm Shakira Richardson, Program Manager with the Department of Licensing and Consumer Protection, DLCP's Consumer Protection Unit, CPU. CPU is the division within DLCP's Enforcement Division that investigates Consumer Protection Procedures Act, CPPA complaints. Bill 25-0930, the Consumer Health Information Privacy Protection Act, CHIPPA, of 2024 would amend the CPPA by making a violation of the law an unfair and deceptive trade practice. Thus, I am happy to appear before the committee to testify on B25-0930. DLCP supports B25-0930, which aims to establish district-wide consumer health privacy protections. This legislation seeks to address gaps in the protection of consumer health data. To the surprise of many consumers, the Health Insurance Portability and Accountability Act, HIPAA, does not provide blanket protections to their personal health data. HIPAA, which applies to certain covered entities, including healthcare facilities and billing offices, protects an individual's private health data and establishes guidelines for the electronic transmission of such data handled by these covered entities. The law, however, does not protect data that is uploaded to online platforms, such as companies' websites, search engines, apps, and health devices. As a result, Personal health data can be collected and utilized on these online platforms without a consumer's knowledge, consent, or adequate oversight. Bill 25-0930 addresses this gap in health data privacy protection. CHIPPA will require companies to maintain a privacy policy prominently posted on their website. The bill would require companies to obtain a customer's consent, which can be revoked at any time, prior to collecting their consumer health. These requirements promote transparency and empower consumers to control how their private health information is used. Furthermore, this legislation would help to ensure companies act in the best interest of consumers. By establishing violations as unfair and deceptive trade practices under the CPPA, the district will be better equipped to hold bad actors accountable. The bill would ensure the health data of each consumer in the district is protected. It would create district-wide standards about how consumer health data is collected and used. The standards would apply to all consumers, allowing them to understand why and how their personal health data is used, shared, and sold, as well as who is using, sharing, and selling it. Violations of this bill would constitute an unfair and deceptive trade practice under the CPPA. As the district government agency responsible for enforcing the CPPA, we wholeheartedly support council legislation aimed at protecting consumers. DLCP's mission is to protect the economic interests of businesses, residents, and visitors in the district by, in part, investigating and enforcing the CPPA. The legislation before us is aligned with the agency's mission. While DLCP investigates a wide-ranging amount of CPPA complaints, we also coordinate with other district and federal agencies, including the Federal Trade Commission. When another agency is better equipped, skilled, and knowledgeable of more nuanced areas. The enforcement of violations to the Consumer Security Breach Notification Law is an example of this. When DLCP's Consumer Protection Unit receives these complaints, we refer them to OAG, where they have the resources and experience to handle these cases. Given the complexities of privacy laws and OAG staff's expertise on these matters, DLCP would handle CHIPPA violations in a similar fashion by referring them to OAG for enforcement. For DLCP, our primary goal is to protect consumers, whether we investigate a complaint ourselves or refer the complaint to another district agency. Ultimately, ensuring consumers are protected from unfair and deceptive trade practices is DLCP's primary focus. I would like to thank the committee again for allowing me to testify. Your ongoing efforts on these issues are critical to the district. I look forward to working with you further on this and other legislative efforts. With that, I'm happy to answer any questions you may have.
Great. Well, thank you all so much for being here. Thank you to the Office of the Attorney General for introducing this legislation. It's funny, as you're sitting here, you guys are presenting testimony, I was thinking about the number of apps so I have two kids who are 5 and 3. The number of apps that I used either in my pregnancy or in those first few, just to track, right? I had one app that tracked contractions. I had one app that tracked how often I fed my kid and the number of poops and all this, like that is actually quite a bit of data. When you think about it, of course, at that time, not thinking of, am I providing consent to this information being sold or shared? But I mentioned that in terms of the pace of technology is just moving at a very quick clip. And health information technology, specifically around fitness and other things, are just kind of exploding. Right now, it is uncomfortable to think about the fact that like our current federal law is not covering any of this. Do we have any reason to believe that Congress will act soon?
The short answer is no.
Okay. Which I think is, I did a fellowship earlier this summer with a bunch of elected leaders from across the country, and we did a session around AI and privacy. And one of the things they talk about is how some of the experts are actually opposed to omnibus legislations because they feel like things can get lost. But say if you really want to get it right, going issue by issue is an appropriate way to do that, or sector by sector. And so dealing with, you know, we did education data years ago. Now we're sort of dealing with, you know, health data. So I think that's important. So I have some questions about the bill, and then also some questions of, with some of the public witnesses also raised as well. So one of the things that came up, especially with the last panel, is around this issue of consent fatigue. The way that you all drafted the legislation, Ms. Marks, it is very much of, okay, I give my consent at the beginning, but if you sell it or change the terms and conditions of how you want to share that information, you have to come back to me for consent each and every time. What's your response to the idea of, if you're asking 50 times, it's meaningless over the course of time?
Certainly, we are sympathetic to consumer fatigue. Our intent was that consent would be only necessary once at the beginning before collection, and then again if it is shared. We do think it is important that consumers have the opportunity each time to say they do not want it shared if a company intends to share that data.
Okay, so is it envisioning of the company changing for whom they were going to share it with?
So right now, CHIPPA requires consent for sharing of, it requires that they inform consumers about categories of third parties that the data will be shared with.
Right.
If those categories changed, then yes, they would need to go back to the consumer. If the third parties in those categories change, CHIPPA does not currently require.
Okay, so this is important for clarification. So it's not you need consent each time it is shared with a specific entity. So if I am deciding I have data and I'm going to share it with Ms. Richardson, and then I have data and I'm going to share it with Ms. Coleman, and I have data and I'm going to share it with Ms. Say, I don't have to go back 3 times if the category of who they are has not deviated from the original.
That's correct.
Okay. Now, one of the things that I'm sure we're going to hear from companies later that it didn't necessarily come up today was, what's the on-ramp for application? The legislation as drafted doesn't provide a deadline for compliance. We don't say by 2026 entities shall X, Y, or Z. Is there a particular reason why you all did not do that?
You're correct that it does not have an on-ramp or a deadline. We are open to including a reasonable time for businesses to come into compliance.
Okay. Let's talk about the deletion request. So I raised this with Ms. Durkin from TechNet. As it's written, as I see it, if a consumer requests that the information be deleted, we provide 45 days for the entity to be able to do so, and then 1 extension if necessary for an additional 45 days. How did you all determine that 45 days was reasonable expectation of time?
Sure. So in drafting CHIPPA, we looked at other states' compliance regimes, and I believe that 45 days is, if not universal, it is in many of the data privacy bills around the country.
Okay. So let's talk briefly about the private right of action, which definitely brought up a bit of heartburn. You know, on one hand, I can certainly hear an argument around this can be incredibly excessive for companies, X, Y, or Z, especially in sort of mistake situations that might arise. On the other hand, the idea that it can only be enforced if the Office of the Attorney General or DLCP acts also seems problematic too, because that just, not to say that you guys aren't going to do your jobs. However, you all can't take on every particular case. So let me ask this just as a clarifying point for the record, Ms. Richardson, does the existing consumer protection law for which DLCP has administers, does it already contain a private right of action?
Yes, our CPPA allows consumers, they still have a private, if they come to us and we investigate anything for them, they still have the right for private right of action.
Okay.
Following our investigations.
How often have we seen that consumers in the district take advantage of them?
I can follow up with some hard data for that for you.
Okay, or maybe, sorry, if Mr. Marks.
I'm happy to speak to that.
Okay, yep.
Though I also don't have hard data, I can say we monitor that. And there's also a provision of the CPPA that allows if a representative action is brought, so if like a class action is brought, not just an individual action or an action by a nonprofit entity, they actually have to give OAG notice. And we have the ability, for example, if we have concerns, we have the ability to step in and effectively take over the case. So there are backstops that give us a role to make sure that there aren't, yes, improper things that we think are sort of over the line, especially if we have concerns about how the CPPA is being interpreted. I would also add that
Wait, so before you add on to that, let's just sort of dig down deeper there. Obviously, you have a particular point of view, and as well as DLCP has a particular point of view. But do you feel as though that private right of action provision in the CPPA has been abused?
No. And I think it has been critical to ensure meaningful enforcement. And because we do not have unlimited resources, and I'm sure DLCP agrees, we cannot go after anywhere near the majority of CPPA violations. The same will be true in the privacy context. What we do at OAG is we think about it in the sense of how can we make the biggest impact to ensure compliance with the law? That is often very widespread actions where many district consumers are affected so that we can come in, make meaningful widespread change and have a deterrent effect. What we do not have the resources to do is when there are individual violations, even very egregious ones, we just can't justify using our resources when one or two consumers have been affected. That's where the private right of action is critical for those consumers to get relief, where they may have been personally affected, perhaps in a very serious way, but it does not rise to the level of widespread effect that our office would commit the resources to it. But we have not seen a deluge of frivolous actions under the CPPA. Frivolous actions are subject to sanctions, and not only would they be thrown out of court if they're truly frivolous, there are disincentives for plaintiffs or plaintiffs' attorneys to bring frivolous actions, and we think that the court system is able to handle those concerns adequately.
All right, Ms. Richardson, you wanted to add?
Oh, yeah, absolutely. So we receive oftentimes after our investigations, if there is a consumer decides to pursue a private right of action, very often they'll come to our office and request a copy of their case file from us. And that's not in a huge, that's not a large number. We see it very rarely. I'm not to toot our own horn, but we're pretty successful at resolving our consumers' complaints and concerns.
Because maybe people don't know. I mean, let's talk about that for just a moment. Generally speaking, let's see, you may not have this data yet, but I'm going to ask, so just give me an estimate for like the last fiscal year. So what was that? FY24, how many complaints did you all receive?
251.
And that's for the total universe?
That's for the total, yeah, for FY24, 251.
Okay, so of those, were any of those related to health data?
I would have to go back and collect that information for you, but I can get that number to you.
I think that would just be very interesting to know.
Okay.
But overall, this is what I'm finding, right? As just with anything, there are a lot of residents who just go on about their daily life, right? And they don't need the government until they reach a problem. And sometimes they may not know where to turn. So in the same instances, like very few people know that we have an ombudsman in Department of Insurance, Securities and Banking, or we have an ombudsman for long-term care that can help you sort of navigate some of these issues, or complaint offices that can help you navigate some of these issues. 251 to me is probably an undercount of the number of issues that people are actually facing because they don't know your office exists. But okay, so 251 total for FY '24. Okay, was that like more or less than FY '23 the year before?
That's right around the same amount. FY '23, but there was 243.
Okay,
So we're right around the same. FY '22 was 381. So our agency is working very diligently with our communications division
okay,
to do some more outreach, to make sure that people are aware that we exist and what services we offer to the public. So we expect for that number to increase.
all right. Let's follow up on whether or not we can sort of drill down in sort of category if it's something that you all do. But this is helpful for the conversation because I feel like anytime someone hears about private right action, there are going to be thousands of lawsuits and it's going to take up all of our time and, you know, all of these pieces and things like that. You know, one of the witnesses talked about Illinois passing or I guess reforming their particular law earlier this year. Have you all talked to your colleagues in Illinois around what was the impetus for that and what they were seeing? You got to turn your mic on.
We are generally familiar with Illinois', I believe it's a biometric law that they passed that does include a private right of action. Our understanding is that private right of action actually resulted in meaningful enforcement of that statute. And I can give you an example of a lawsuit that was brought. So there was a class action lawsuit brought against Facebook that forced scraping without consumers, scraping people's photos and creating facial profiles that would meet the definition of biometric data. That brought to light that issue and it brought significant restitution for those consumers that were impacted.
Yeah, and Meta no longer uses that particular tool. Okay. Hang on, just working through some questions here. Okay, the bill as drafted allows for entities to charge administrative fees for requests to delete health data if the requests are manifestly unfounded, excessive, or repetitive. Now, I'm not suggesting that we define any of these words. However, what are you all trying to get at there? Because even if I think we have this ongoing separate issue here in the district where, you know, in order to go to school, you have to have particular immunizations, et cetera. And our public schools and our private schools require that you turn in a form that basically says, yep, you're up to date. And now we have doctors' offices who are charging for that form. And so it's like the thing I need to go to school, you are charging me for to literally write down the information, my health information, to write it down. That's a separate issue. But to them, those doctors' offices will say, we're a small pediatric practice with only 3 people, and therefore that is excessive for us to take time to fill that out or something to that effect. So how are you all sort of thinking about this?
Sure. So I believe CHIPPA allows consumers to request that data twice a year.
Yeah.
And the provision that you referenced was sort of a stopgap to prevent frivolous requests that would just burden the company. We are open to addressing any concerns that council may have on that.
Okay. All right. Let's talk about the exemptions. We had testimony from the DC Hospital Association as well as AHIP on the health insurance plans, who suggested that we exempt health entities who are covered by HIPAA. What are your thoughts on that?
So they correctly noted that we exempt HIPAA covered data, but not all HIPAA covered entities. The intent there was to prevent any sort of gap in the law where, because HIPAA does cover data and it does cover entities, where a HIPAA covered entity has data that isn't covered by HIPAA. that they are using, processing, and
Do you have an example?
I'll reference my testimony. So if a health insurance provider is collecting information about a medical records or billing statements, that data would be collected or be covered by HIPAA.
Mhm.
However, if that health insurance provider is collecting other health data that is extraneous to medical records or billing statements, for example, to set policy standards or to set policy premiums, then we want to make sure that that data is covered by CHIPPA.
Okay. So I would think about it from this perspective, put AHIP aside, but like for our Medicaid MCOs, they have a lot of data and information about lots of district residents and children, right? Everything from every doctor's appointment you've taken, what procedures you've had, right? When you talk about billing information, that's getting into sort of the very specific pieces of whatever what was the procedure that was done and that was accomplished there. And then they would say, oh, we have other information on like, that help us sort of address some of the social determinants of health. So they might have information on weight. I guess that is your weight HIPAA protected?
I can't, I think.
I'd imagine it is. But say like if somebody uses a food pharmacy, that gets into a question of like, is food health information on that front? But I guess I'm trying to see a path here, not a path per se, but just trying to get some clarity in terms of why a hospital who, let's just use hospitals for instance, like a hospital is a HIPAA entity. Variety of health data that a hospital has is already covered by HIPAA. Why would we not cover, or why would we not exempt the hospital or the health provider?
Right. So as you referenced, the hospital's data that is already covered by HIPAA would be fully exempted from CHIPPA. But to the extent that that hospital has health data that does not fall under HIPAA protection, CHIPPA would step in.
Okay. Then I guess I need some clarity around what is health data that would not be covered by HIPAA. That
I can give an example to
Okay.
maybe help clarify. So, for example, we've talked, in Ms. Mark's testimony, she talked about the inferences that are made. So there may be data that in and of itself is not health data. Purchases, perhaps how many times someone goes to the hospital may not be protected by HIPAA because it's not health data. But if the hospital is then making inferences based on that, we want to make sure that that's protected too. Or for example, another concern we have with whole-scale exempting an entity is we don't know what other business streams that entity might have. Maybe the hospital decides to have a fertility app and to collect data through that way. We want to make sure that that has protections as well, and a blanket exemption for entity, no matter what data they're using, no matter what business models they have, are concerning. We would also say we want to make sure the line is clear so that hospitals and other entities know what's covered by CHIPPA, and hopefully they already know what's covered by HIPAA. We just want to make sure there aren't gaps.
I think that's that kind of gets to the conversation I was having with Mr. Schwartz around like the mothership, if you will. So many of our health institutions now are considered systems, right? And so if we exempt the entity, are we exempting the system? And what if the system includes a university? Okay, point made. I'm sort of thank you for giving me grace to sort of work through that particular piece, but I would love to have more conversations on that part. Let's talk a little bit about geofencing in the conversation around I was having with one of the public witnesses around the definition of consumer. So first, what were your thoughts in response to the critique on the definition of consumer and how that can be open to essentially tourists or visitors in the district.
So consumer is defined in CHIPPA as a mirror of what it is in the CPPA and our data breach statute, which is not only residents, but those in the district. Our intent behind that was to protect individuals who enter the district and are seeking medical care.
Okay.
I do want to respectfully disagree that the geofencing bill as written, or the section of the bill as written, would protect any person because it does reference consumer.
I see. Okay. Gosh. All right. This makes this, I feel like the district perhaps differently than perhaps Washington State or some other entities, because I like to think of us as a tri-state area. Yay, statehood. But also I know specifically in the reproductive health space, I got thousands of people who are coming to the district every week who are not district residents, who are seeking particular health care here in the district. And that can be the same for Maryland and Virginia, right? You might live in Maryland, but you work down the street from your dental office or something like that. And does that mean that you are not protected? I guess the question is, and you're saying this definition is the same that we already have on the books in terms of CHIPPA. Have there been issues or conflicts that have arisen there around jurisdictional concerns or application concerns?
No, as far as, so we've been enforcing the data breach notification law for several years now. And as far as we are aware, entities are able to comply with that law.
Okay, Ms. Richardson, you want to add to that?
I agree with.
Okay, good. Two agencies. I just want to make sure everybody is on the same page with music.
If I can add on that piece, just
Sure.
because we've seen especially the application of our general consumer protection law in the digital space. And actually, it is the way that these tech companies, these apps have evolved. It's actually very easy for them to, for example, have different interfaces at different platforms for different jurisdictions, because they can essentially, they know generally when you're passing from one jurisdiction into another, and they can know that without very precise location data that gets into the geofencing concerns. And so we've had situations where we've taken a certain position, for example, against, what we view to be predatory lending apps. And as a result of our action, they've actually chosen to at least either not make their app available in the district or to have a different, more clear disclosures in the district. And they can do that and have actually different interfaces that apply in different jurisdictions, which actually would, in my view, be easier than defining it as a resident, in which case they need to know what your address is. You just need to know is it being collected while someone's physically in the district, which apps do that all the time. They understand that about their users all the time.
Okay. From a drafting perspective, because I have my general counsel in my ear, not physically, but I know what he's going to say. Is there any reason that we wouldn't say consumer means the same definition as consumer in the CPPA?
We would be
Just from a drafting perspective, I'm sure that he would clear it up. But also, I think that's important for folks to know that we're not establishing something new. This is something that has already been on the books. Any?
no concerns.
Yeah, I will probably triple check the language just to make sure, but that strikes me as reasonable and shouldn't create any unintended consequences.
Okay. Okay. All right. In terms of the geofencing piece, are there any states that have already enacted geofencing technology bans?
There are, and Washington State being one of them, but I believe there are several others, including Virginia and New York.
Okay. I'm just gonna take a wild guess that Massachusetts will not be far behind on some of these things, knowing what's happening there. Okay, geofencing is not the only mechanism that uses geolocation data to direct ads to consumers. In some instances, we've got geotargeting using GPS or Wi-Fi or IP addresses to determine consumer location and target their ads. There's this new, method, beaconing. Businesses essentially place small radio transmitters inside or outside of their locations, and those beacons can connect to a consumer's mobile device and send ads when the consumer is near the beacon. Whew, that could be so abused. But nonetheless, here we are. In your discussion with consumer protection lawyers and data privacy stakeholders, has regulation around geotargeting and beaconing also been raised?
We have not had conversations about other technology that we might want to address. But we are, if the council's concerned about that, we are open to including those in CHIPPA.
No, I think we should, particularly around beaconing. To me, sounds very like if you have your AirDrop open and you're on Metro and then somebody just drops pictures to everybody at a, like, that has happened. And so the idea that not even a business owner, but like an advocacy organization or something like that could set up a radio transmitter and just like ping something straight to your cell phone, that is just very problematic. As we think about, like, unfortunately, I don't want to like legislate to the lowest common denominator, but I got to think about how some of these crazy people think. And these are how I feel like this is a type of thing, however new, can very well be weaponized against people in the future. So if you guys can sort of check in on that and get back to us, that'd be great.
Absolutely. We share the concern and would be open to that.
Okay. Okay. The legislation has okay, hold on. Hang on one second. Okay. I think it would be helpful for me to just get a better understanding of how your office, in terms of consumer protection with DLCP, works with your office, and how that would apply to this. Luckily, you guys have already been doing this with CPPA, but let's say, for instance, I'm a resident and I contact your office. What happens from there?
That's a great question. Thank you. So if a consumer contacts our office with a privacy concern, we will search every database that we have available to us for licensing, because we also oversee all licenses and corporate registrations for businesses in the district. So we will search every available database that we have available to us to compile any relevant data that's to assist with the investigation of this complaint, compile that, and then make a referral to OAG or to the Federal Trade Commission to make sure that we're not just passing over a blanket blind referral. We're actually providing any relevant data that may assist our stakeholder agencies and sister agencies with resolving the customer's concerns.
Okay. And so are there any, at what point or at what level would you refer something to the OAG?
If there are concerns of this nature and we cannot identify a respondent, and OAG has greater resources to better, and people who are specific, have specific skill sets to better investigate these complaint types. We normally, if we receive this type of complaint, we normally make the referral with all of the relevant information pretty much instantly, especially if we can't identify a respondent.
Okay.
I can speak to our side of the equation,
Yep.
which is, and I really, it is a very complementary relationship in that both agencies have enforcement over the CPPA and for anything that's a violation of the CPPA, but there are just things that naturally fit in one of our wheelhouses. So on the other side of the equation, when we get complaints about licensing issues, when we get complaints about violations of, brick and mortars violating the district's flavored tobacco ban, DLCP has far more on-the-ground investigators that can go to these brick and mortars.
Mm-hmm.
At the same time, on the privacy issues, one, we have Ms. Marks as well as another privacy professional in-house. We have multi-state relationships with other states that do privacy work. We actually have relationships with nonprofit organizations that give us essentially free expert advice. And because of the privacy work requires us to peek behind the curtain and we have the subpoena power to see what's actually being done with the data, that does tend to be what we end up handling. And so we ask DLCP, and I know they do it. Everything that falls in that category comes our way. And we try to address every single one. Every single one won't lead to a full-blown investigation or litigation, but we have other soft enforcement mechanisms, including through our mediation program, where we'll, at a minimum, we will do informal reach out to the company to let them know we're looking at this, and that almost always, even if it's a small scale concern, they'll get into compliance.
Okay.
And that's sort of how it works in practice, certainly with the data breach law, and I think it would follow that exact same template with this law.
So Ms. Richardson, what's the most common resolution for the complaints that are brought to your office?
For data breach or just consumer protection?
Consumer protection in
For
general.
consumer, we mediate, and we're generally successful with mediation and making
Okay,
our.
mediation is
Yeah,
the,
we attempt to mediate, number one, for compliance. We want to bring the company into compliance with the CPPA as well as the licensing and registration requirements of the district. So, and we're very successful with that. And we also want to make the consumer whole. So, and we're very successful with that also. We're making sure, as you see, we have a large enough volume to make sure, and enough investigators to make sure that we are working full time to make those consumers whole when they bring us those concerns.
how many investigators do you guys have?
Strictly for CPPA 8.
Wow. You got more investigators on CPPA than we have in mold inspectors in the district.
Yeah, so we have, they handle all CPPA and all 12 boards and commissions for our professional licensing,
Right,
all
the
of those
occupational
complaints
boards.
also.
Okay.
So they're pretty busy. They stay very busy, but we're very, also very successful in mediating those concerns.
Okay. When you are doing mediations or conversations with small businesses in particular, is it often that they will say like, I didn't know? Like,
Very-
or how often?
It's very, very often. They always say, oh, we weren't aware, or we didn't know, or in our contract, they're very crafty with their wording in a lot of their contracts. And we just make it very clear, like that's an unconscionable term in your agreement, and we work with them to bring them into compliance. We make sure that they make the consumer whole also. But that's very frequent, especially with things like flavored tobacco. But that's, we know that that's not true, because before any legislation is ever enacted in the district, our agency as a whole, including our investigators and all of the investigators, we go out and we do a lot of education prior
So
to.
that was gonna be my question around like, let's say we move forward with CHIPPA. What is the process or reasonable process for informing companies who, whose products or applications might be live in the district of like, hey, it's a new day?
So we maintain all the licenses for all the businesses. So we definitely have a list. Our Business Licensing Administration will pull a list from them of every licensed business.
Right, but you have mainly, well, not mainly brick and mortar, but to the extent that your directory is also capturing some of these technology companies that may not be based in the district, but are providing services in the district. How do we capture those?
So, and that's something that we would have to work with our sister agencies and our stakeholder agencies to create a plan of action.
Sure, and I can say we very often send out things like consumer alerts and business advisories to sort of, especially with a new law.
Okay.
To make sure that and we push out through our own communication channels, through working with council members through their communication channels. I will also say, as it was reflected in this hearing, tech companies are very alert to every new privacy bill that is passed in any state or jurisdiction. And so, and through their trade organizations, et cetera, who we're always happy to work with to get out these things like consumer alerts.
Yeah.
And look, companies that are trying to, I can say for OAG, companies that are trying to comply, we're not going to take punitive action against them if they, if they truly are not aware of the bill, if it's, brand new. We don't want to use our resources we want to use our resources against those that are really the bad actors who are knowingly not complying with the law.
Okay. Let me just check my notes, see if they're. Okay. I don't think I have any further direct questions on the legislation. Obviously can follow up with you guys specifically in terms of language. Is there anything I didn't ask you that you wanted me to, or that you want to make sure that you get on the record publicly today?
One point that I did want to clarify was the definition of consumer health data. We've heard today that from a number of industry folks that they feel that the definition is unclear and that it's overly broad. We respectfully disagree and think that the definition clearly establishes that consumer health data needs to identify the consumer's past, present, or future physical or mental health status. But we are, again, happy to work with them on any additional language that may clarify our intent.
Okay. Ms. Richardson, anything else?
No, not at this time.
Okay, awesome. All right. I'm so sorry. We've been joined by Councilmember Nadeau. Councilmember Nadeau, do you have any questions for the government witnesses?
I actually, can you hear me okay?
Yes.
Great. I don't have any questions. I wanted to pop in, sorry to miss the bulk of this. I wanted to pop in and just make a little bit of a statement on the importance of this legislation whenever you think is appropriate.
Oh, now would definitely be appropriate.
All right. Well, I really thank you, Chairman Henderson. As chair of the Committee on Public Works and Operations, which includes the Department of Licensing and Consumer Protection, I want to applaud Attorney General Schwab and the Office of the Attorney General on their efforts to strengthen privacy rights for district residents. The Consumer Health Information Privacy Protection Act of 2024 will expand data privacy provisions to apps that collect and sell our private health data. Consumers turn to these apps because they offer immediate and low barrier care and the chance to take charge of their own health. But they often don't realize that these apps are not governed by traditional health data privacy laws and are selling our data. And there have been numerous reports of apps selling even our most sensitive data, including data on mental health, reproductive care, and genetic testing. These privacy rights have even become more urgent as threats to reproductive and gender affirming care have been increased across the country. And this data is being weaponized to prosecute people for simply looking for care. Many consumers have no idea and no way how to opt out. As a woman and the mother of 2 daughters who will become teenagers and young women before I can blink an eye, I'm terrified, to be honest, by the possibility that the most personal of information about me and my body become fodder for marketers, insurance companies, even the government. And I'm terrified for tens of thousands of others in the district who face the same invasion of privacy, many of whom will not even know it's happening until it's too late. Protecting consumers in the district is a responsibility I take very seriously, and I'm happy to see the Attorney General and my colleagues here at the Council agree, and I look forward to continuing the discussion and learning more about this bill as we move forward with the legislation. So thank you very much, Madam Chair, for the opportunity to join you today.
Thank you so much, Councilmember Nadeau, for presenting testament or providing that statement. I had time, so now I have another question. Sorry. I wanted to follow up on something that I think Mr. Schwartz from Consumer Reports raised. He mentioned that when in Maryland's sort of larger bill, they just did an outright ban on the sale of health data. Is that something you all considered? And if so, why did you choose not to go down that path?
So we did review the other data privacy laws that were primarily in effect, and Maryland's law passed earlier this spring and is not yet in effect.
Oh, I see.
And so we think that requiring an authorization before the sale is a good place to start. But if council is interested in outright ban, we would be open to discussing that language.
Okay. Ms. Richardson, do you have anything you want to add on that?
None of it.
Okay. All right. Well, I want to thank all of the witnesses for testifying. I want to thank the government witnesses for being here and for your willing partnership on this. The record for this legislation will remain open until 5 p.m. on Thursday, October 31st. Halloween, I know. But get it in early and you won't be late. So you may submit your written testimony as statements on the council's hearing management system website. Go to dccouncil.gov/hearings. And you can just upload your testimony right there. We do have a couple of follow-ups in terms of some of the data that we wanted and you guys looking at beaconing, and we'll continue to have some of those conversations on that front. I just want to reiterate again, as a PSA for the folks who are watching, this, do not wait and come to us in the last minute about particular concerns or wanting to have a conversation about this particular piece of legislation. You need to get in before the end of the calendar year. Before the end of the council period, actually, because the council period ends before the calendar year is over. All right, the Committee on Health will hold its next public roundtable on Tuesday, October 22nd at 9:30. We will consider one nomination to the Board of Respiratory Care and 3 bills. Oh, wait, I'm sorry. It will not be a roundtable. It will be a markup. We are marking up these bills. So we are marking up one nomination to the Board of Respiratory Care and 3 bills. Bill 25-571, Seizure Safe Schools Amendment Act of 2023. Bill 25-672, the Radiation Protection Act of 2024. And Bill 25-759, the Child Behavioral Health Services Dashboard Act of 2024. Again, if you have interest or comments on these bills and you didn't get them in during public witness testimony, please don't come to the committee the day before we vote. Pay attention. Let's get in the comments now. But there being no further business before the committee, the time is 11:42 and this hearing is adjourned. Thank you.